Okay, so welcome. So tonight, as I suggested, we're going to devote the first 20 minutes to me providing some suggestions on how to mark case notes assessments as part of your peer marking and peer review process. And then at about 7 o'clock, we will begin with the actual tutorial that talks about judicial review remedies. So tonight, for this particular session, after studying this topic, you should be able to discuss and explain the key aspects of the case notes assignment and why those key aspects are important. You should also be able to apply guidelines on how to mark and provide feedback to the case notes assignment, identify orange or red flags in a case notes assignment, and examine and evaluate as part of a scaffolding process an actual peer marking feedback and feedback that I will do in relation to the case notes of 4. Okay, so that's what we're going to do. Any questions before we continue? So we're good. Okay, let's begin. Now, what are the key aspects of the case notes assignment? Let's begin with that, just for us to be able to get grounded on why, what are the key aspects that we're looking at. So of course, you begin with the facts. The facts are crucial because they give you a sense of and signal what the legal problem and the legal issue are. So without the facts, all you end up having would be the legal principles. And then as we noted, especially in relation to a lot of the quizzes that I've drafted, you could get your answers wrong depending on the facts. So the facts are really important. Now, the facts are important because, as I said they suggest to you what the legal issues are. And so if the facts are properly presented, and when I speak of the facts, there are at least 3 areas that we should be looking at. We're looking at the applicant for the purpose of determining, I'm just gonna turn off I'm just gonna mute everyone else. So we're looking at the applicant for the purpose of determining if that person actually has legal standing and whether any of his rights, interests, or legal expectations might have been breached, to then give him a legal standing to initiate either an application for judicial review or perhaps apply for merits review with the Administrative Appeals Tribunal. So you're looking at the facts in relation to the applicant. You also want to know what the law is, the law that is involved. So when a decision maker makes a decision, is that decision maker making a decision, for example, on the basis of a statute? Because we will recall that if the decision is based on a statute, particularly what we call it as an enactment, then we can say that in all likelihood, the Administrative Decisions Judicial Review Act of 1977 Commonwealth can be applicable, can be the basis for an application for judicial review. Otherwise, we need to examine whether an application for judicial review can be based on the Section 39B of the Judiciary Act of 1903 or Sections 75, subparagraph 5 of the Commonwealth Constitution. And in this particular case, if you're referring to Section 75.5 of the Constitution or Section 39B of the Judiciary Act of 1903 Commonwealth, that is because we would assume that the administrative decision was not based on an enactment, but perhaps was based on the exercise of non-statutory executive powers, which can refer to prerogative powers. It could refer to implied powers under the Constitution, or it could refer to Section 61 of the Australian Constitution, which tells us what executive powers are all about. So the facts are important. The legal issue is important because what we need to know is that once we've gone through the facts, what then is the legal issue? Because the legal issue would suggest to us what the relevant rules should be. So these are all interrelated, they're all interconnected. So by reading the facts, you get a sense of what exactly is the problem here. Now, the problem is not the same as the legal issue. The problem can be as simple as, is there something wrong with the decision? Should this particular applicant have been entitled to particular benefits? So that's the legal problem. But the legal issue is you connect it to an administrative law principle. The administrative law principle might be that you might ask, does this person have legal standing? You might ask if there is a ground for judicial review. You might wonder if there is a judicial review remedy that you can specifically identify because, knowing the case of Green versus Daniels, You want to know that if you apply for judicial review, you will then be able to get the order that you want. Because in the case of Green versus Daniels, we will recall that the High Court said that even if he was prepared to say that the decision maker was wrong, the applicant, the High Court judge was unable to issue an order that would actually grant the benefits that he felt would have been deserved by the applicant. So there is a limitation to judicial review, mainly because, as we recall, in an application for judicial review, in most cases, what the judge does is to quash the decision, but he cannot substitute in the normal in the normal happening of events. He cannot substitute his own judgment for that of the decision maker, nor can he remake the decision of the decision maker. So that's the problem there. Okay. Now, there are two aspects to the third. There are two parts to the third aspect of the case note, and that relates to the decisional rule. So the decision refers. Where's that coming from? Somebody seems to be. Where are all those lines coming from? I wonder where they came from. That's not from me. Surprising.
Oh, Manjo, it's Monique. I'm on my iPhone and I've tried to get up the chat box, but it's given me a pen and I've drawn something on there. I'm so sorry. I've got no idea how that happened.
Yeah, I didn't realize that participants could do that without me.
Oh.
That's all right. Now we just leave it there for now.
I'm so sorry.
Things look here. Okay, so the decision, there are two parts to it. One is, a decision refers to that aspect whether whether the decision would be wrong, whether or not the person may have legal standing. It could be the decision can say that the decision is invalid for reasons for whatever. Okay, so that's the decision part there. Now, the rule is a way by which. Hang on, there's so much background noise. I'm just going to mute everyone again. And let me see what's happening there in the chat box. There seems to be a chat going on. Oh, okay. So in addition to the decision is actually grounded by particular relevant rules or legal principles. So the reason why a decision was arrived at by a judge was because there are relevant rules or legal principles that compel him to arrive at that particular decision. So those are two things, as we will later on see. So you have a decision saying, you're probably going to get this. There could be a decision that there was an error in the decision of the decision maker, and then that is explained by the relevant rules or legal principles. So that's another aspect. And if you will notice, as far as the weight of the marks are concerned, the heaviest weight actually goes to decision or rule. That's 40%. Now, the importance of the case, we want to know, from the viewpoint of the student, why does the student think that the case is important? From the viewpoint of administrative law, so that has to be articulated. That particular point is actually where the intellectual input of the student becomes more evident, because the facts, the legal issue, the decision or rule, in those cases, what the student does is to draw from the case these aspects of the case. But the importance of the case that is coming from the student himself or herself as to why he or she thinks the case is important from the viewpoint of administrative law. And that is awarded 20%. And then 10% goes to language use, formatting, etc. And of course, the way that language is used, the way that the case notes have been written, that would indicate either professionalism on the part of the student or sloppiness in writing, in formatting, in referencing, and in following instructions. So we want to be able to observe those. Okay, so I've explained so far what the key aspects are of a case note and what we hope to be looking at as we go through the process of marking and then providing peer feedback. Now, what are some of the orange or red flags that we want to watch out for? The first is the problem of plagiarism and or the failure to paraphrase. Now, we will recall that in the marking guidelines that I gave, students are only permitted to quote, how many was that? about 50 words or less. I can't remember now. But there was a guideline that in relation to the number of words that a student can quote, we limited that to a few words. And I can't remember now how many it was, but a maximum of 20 words throughout the case note. And the reason for that is that we want the student to be able to paraphrase, to be able to use his own words and use his own ideas in writing the case note. Because otherwise, if all the student does is to just do an excerpt, the facts, do an excerpt of the stated decision and the rules, that's not much in terms of intellectual contribution. So the requirement here is that we will only allow 20 words to be quoted from the case. The rest have to be in the own words, in the student's own words. Okay, are we clear on that? Now, in addition, the other orange or red flag will be a failure to follow the word count limit. So we will recall that the word count limit is, the range is between 500 words, I think, to 600 words. It can't go beyond that. It cannot go beyond 600 words. So if a student writes a case note that goes beyond 600 words, you need to mark that down. And if it's overly long, you actually have you could actually ignore reading, the rest of the case notes beyond 600 words. We are not compelled to read a 1,000 word case note because the instructions are clear. The range of case note, the range of the word count is only between 500 to 600 words. So if it's overly long, that case note has to be marked down. There's also a giveaway about whether the case note is professionally done or not. And part of it, the giveaway, is actually the formatting. So if the student, for example, uses different fonts, different font sizes, the margins are not properly done, then you get a sense that the case note has really been sloppily done. And if you're dealing with case notes which have been submitted by a group, and let's say of 2 or 3 students, and the group did not even bother to properly format their case notes, again, that indicates that that's sloppy work. You don't want to be able to see that when you submit a pleading, for example, in court. So that's an orange or red flag. The other important point they have to consider is actually the allocation of the word count according to the relative marking weight. And because we know that the criterion that has been given most weight is the decision or the rules or legal principles, then basing it on 500 words, we would have a sense that more or less the decision or rules or legal principles should be discussed using about 200 words, more or less. The facts about 20% or 100 words. So if the facts comprise, let's say, 300 words of the case notes, you have a serious problem with that case note. There would be too much facts, and there would be very little discussion of the legal issue, very little discussion of the decision rules, and very little discussion of the importance of the case to administrative law. So you ought to be looking at not only about the total number of words in the case note, but you want to be able to determine how the word count was actually allocated across the 4 key aspects of the case note assignment, which are the facts, issue, rules or legal principles, and then the importance of the case to administrative law. Okay, are we clear so far? Because then what we're going to do next is to actually examine maybe 2, 3, or 4 case notes. I'm going to provide my feedback as we go along. Would that be all right? Any questions so far, or could I go to looking at
yes, Manjo, I had my hand raised there. You made mention of font sizes.
Yeah.
Does that apply to headings and all of that?
No, I'm not overly concerned with that. Number one, an example of sloppy formatting would be because I didn't really give guidelines, right? But we would get a sense that when somebody submits a Word document, you would assume that the usual font size would be 11 to 12 points. So if somebody uses font size, which is about 20 points, that would be too much, right? Or if somebody uses font size, which is 8 points, they would be too small for anyone to read. But otherwise, between 10 to 12 points, that's fine. Now, if within the same case note, you notice that some words are using 10 points and then others are using 12 points, that's an example of sloppiness that I'm talking about. Or when some of them are in Arial in the same case note and other words are actually using Times New Roman or whatever, Calibri, you've got a problem there. That's being sloppy. So those are the concrete examples I'm giving.
Oh, well, that's good. Another reference to word limits.
Yes.
Are you talking about individual notes or across the board? Because in some cases, some case notes might be shorter and the other one might complement the short notes to make the total number of case notes needed. The overall number, like words counts. Is that what you mean about word limit, or is it specific on individual case note that they have to be 500 in total?
Yeah, the instructions in the unit profile, as well as in all the guidelines, are very clear that the word count is in relation to each case note. So you cannot have, let's say, somebody submitting 3 case notes, and one of the case notes only has 200 words, and then the next one has about 800 words. The first one would fall short of the word count range. The other one would be excessive. You cannot add them up and then divide it by the number of case notes. It has to be per case note, because that is the specific instruction of the case note assignment.
All right, good.
Okay.
Thanks.
Now, it's almost 7. How do you suggest we do this? Do we talk about the topic now on judicial review, or do I extend it by, let's say, 15 minutes to just finish this activity, and then we talk about the tutorial topic on judicial review remedies, with the understanding that we could extend by a few minutes after 8 p.m. Queensland time? Would you rather that we just finish this up? The topic on peer marking and peer review? So Leona says she's okay. So Emma says this is important. Okay, good. So let's try to devote about 15 to 20 minutes, maybe 15 minutes to this topic about peer marking and peer review, because a lot of clear indicated that it is important. And then we will begin talking about the tutorial topic a few minutes after that. Now, we were fortunate to have had a group of students, Monique and Sarah, and who was the third one? I can't remember now. Who agreed to have their case notes be the subject of tonight's review process. We also had that of Jay, or was it Leonie? So Leonie is part of the group. And then we have Jay as well. Is Jay here? Okay, Jay. Jay, I'm just curious, are you written down as Jay Beveridge in the file?
I'm written down as Courtney Beveridge. Jay is my middle name, and I use Zoom through Facebook. So only my middle name's on Facebook. So it's Courtney is my first name, yeah.
Okay, very good. So I wanted to make sure, because I didn't want to end up using the case note of another student without his or her.
Oh, yeah. Okay, that's me.
Okay, very good. Okay, then. So hang on. So let's begin with Courtney's case notes, I think. We'll probably just go through 1 or 2 of them, and then we'll shift to the case notes of the group of Monique. Now, so again, as I said, I'm thankful that, do I call you Courtney or Jay?
Courtney.
Courtney, okay.
Jay, whatever, it's okay.
Thank you. So I'm thankful for, to Courtney for agreeing to use her case notes. So let's go through this. Oh, sorry, hang on. Okay. Now, how do we do this? Okay, I'm going to give you enough time to go through the facts, because otherwise, if I give my comments straight away without you being given the opportunity to read the facts, it's all going to be very abstract. So I'll give you a few seconds or a minute to go through it. and then I'll give my comments. Hang on, sorry. Let's begin with the first one. Sorry about that. This is the first one. So we're good, I think, with the facts. We've gone through it. It's quite short. So that's good. So I think in terms of the word count, what I would have done was to check in word tools, I'll look at the word count number. But I think that's kind of within the word range, which is about 100 words. Now, these are my comments. Now, remember, the facts are meant to assist us to arrive at the legal issue. Okay, so when you read the case facts, you will have a sense of what the legal issue is. Now, we actually have a lot of examples about how the case facts are written, because all the quizzes that I've made, and I've written 9 so far, and I've probably written more than, 30, 40 discussion problems throughout the term. Those are examples of how case facts are written. So when you go through the case facts, you do have a sense of, what seems to be the legal issue here, and, it creates some kind of a problem. You get a sense that there is a problem, and you want to know what the law should be. Now, so the facts are crucial. The first problem that so again, currently, this is just a very clinical exercise for the purpose of, learning for everyone. The problem I see, the first problem I see with the case facts as written here is that there is no reference to the law. So, so there was a decision, obviously, and the decision was made on the basis, a decision was made not to give unemployment benefits to the applicant, to the plaintiff. But we don't know in the first place why the applicant is entitled to particular benefits in the first place. Is it because, does she have a right? And if she doesn't have a right, is it based on a statute, or is it on some kind of natural right? We don't know. It would have been very important at that point that we have a sense of what statute is involved. Or if it were not a statute, was it because there was a regulation that was written by the minister, the decision maker, that then prevented the plaintiff from receiving benefits? Now, we will recall that I actually made an example of a case note based on the Green versus Daniels case. And you have it in Moodle. And I think, I'm very glad, as far as Curtin was concerned, I'm very glad that she obviously did this originally. She did copy from the case notes which I wrote, which I acknowledge that. That's very good. Now, in relation to the facts, actually, for this case, there was the law actually would have entitled the plaintiff to the benefit, to the unemployment benefits. The law entitled the plaintiff to the benefits. However, the decision maker, the minister, I think, or the secretary of employment services, he issued regulations that said that for a certain period of time, immediately after the school term, students, the school leavers, were not entitled to unemployment benefits. So in a sense there, you see that there is a problem because the regulations, in a sense, contradict that stated in a statute. So there is a drama there. There is a dilemma. What then do we do? There is a conflict. Do we rely on the statute or do we rely on the regulations? Which should then mean that the decision of the decision maker would be valid because he simply followed regulations, which generally we know would be valid. Now that is absent in the facts. So to me, that is a crucial shortcoming. And so following that, in terms of the legal issue, it hasn't been articulated quite well in the legal issue, in the sense that this is actually more of a restatement of the problem. And the problem is the applicant entitled to unemployment benefits? It doesn't link itself to the legal issue. To any... What was that?
It's Jesse here. Sorry to interrupt. Can I just ask a question?
Go ahead.
You're making reference that this particular student didn't quote the statute or the legislation within the fact. Did they reference it though in the footnotes in an attempt to try and save a word count? Do we take that into consideration?
It could have been. It's not there. Okay, so we're looking at that one now. These are the footnotes at the bottom. They're not there. Now,
okay, so no Social Services Act,
no,
1947.
In fact, what is crucial is that the statute itself should have been stated in the facts. And the key points of the statute should have been there, including the regulations should have been there. There should have been some statement. Now the full provisions, they can be in the footnotes, but the facts themselves should give us a sense of what the statute or the regulations might actually be talking about. So that is a huge gap there. Now, so I've already highlighted to you the factual problem we have. So we have a statute that was contradicted by a regulation. So the first legal issue would have been, and this is actually captured in the case notes that I wrote, and I'm going to show it to you in a short while. One of the first questions we have is that what actually happens when you have a regulation, which is what is known as subordinate legislation, that contradicts a statute or the primary legislation, which ought to be followed? That's problem one. And if the regulations are inconsistent with the law, will the regulations still be valid, or will the regulations to the extent of the inconsistency be invalid? That's one of the questions, because if the regulations are invalid, then the decisions based on those regulations may then be invalid, or they would be contrary to law. That's one. The second legal issue, though, is that knowing our background about administrative law, that administrative law is, especially judicial review, is of limited scope. We know that even when there is a strong basis for judicial review, what happens then is that the court will quash the original decision, but the courts will not remake the decision of the decision maker, neither will the court substitute its own decision for that of the original decision maker. Because we know this as a background, we then ask that legal issue, assuming that according to the law, according to the statute, the applicant is actually entitled to the unemployment benefits because we assume that the regulations are invalid for being contrary to the statute. Would it mean that in an application for judicial review, the court can then issue an order granting unemployment benefits to the applicant? Can you see, how I articulated the legal issue there? I moved away from just the legal problem, but actually formulated legal issues there. And I'm going to show you how I did it by raising the example I have of my own case notes. Well, now, give me a second. Okay, here we go. Okay, so these are the facts. You have this in Moodle. It talks about the Social Services Act because that is the act involved. It talks a bit about the provisions, but then it tells you that the Director General issued a policy which effectively disqualified any school leaver. So there's a tension there, which the facts are telling us, that the Director General issued a policy that was contrary to the statute. In terms of identifying the legal issue, the basic question for us was that, assuming that the decision maker made a wrong determination in his decision, would the plaintiff be entitled to the relief sought? Particularly that the court make a declaration that she is qualified to receive the unemployment benefit for the subject period. So that is the legal issue there. Okay, now in the footnotes, you will notice that this is the law. We don't really count that for the purpose of the footnotes, but if you wanted to know more about what the statutes or the regulations are, they're all there. Now, so going back to the case notes of Courtney. The problem I have here is that it's a bit too factual. It doesn't tell me what the rules, the relevant rules or legal principles are. In fact, I can't, essentially because the facts did not say that there was a problem with the regulations being contrary to the statute. That hasn't really been discussed in the rules. So what I have here is just the decision, and the decision was that satisfaction was a question of fact, but instead a question of the Director General's state of mind. Okay, so if that is the case, what's the legal principle there? That's just a statement of the decision. The court noted the applicant was not deemed unemployed. It's still so much about a finding of the court, still about the decision. It doesn't tell us what the relevant rules are. The legal principles were not really discussed here. So if by reading this, there is not much that we could get from the viewpoint of understanding administrative law. There's a big problem there. I'll show you the one I wrote. Hang on, where am I? Okay, so what I did was, in terms of the decision rules or legal principles, the decision of the court, the finding of the court was that the Director General's policy was inflexible. And while he may issue guidelines about what he might consider as justifying the attainment of a state of satisfaction, these must not be inconsistent with the statutory criteria. Otherwise, and this is the principle here, he would act unlawfully, and the decision of delegates based on those guidelines would then be vitiated. That is the legal principle there. So if a decision maker issues guidelines or regulations that contradict a primary legislation, that regulation, to the extent of the inconsistency, would be unlawful. Decisions that emanate from that unlawful regulation would then be unlawful as well. So that would be the legal principle. And the court found that this is what happened in the present case. Now, however, assuming that that is true, that the decision was therefore in a sense invalid because it contradicted the primary legislation, does it mean that the court can grant the unemployment benefits that were sought by the applicant? And from the rules, what we have here is that the court held that even if it were to agree with the facts as asserted by the plaintiff, and that the court made the finding that the plaintiff was entitled to the unemployment benefits during the period claimed, the relief sought was still not open to it. The relief sought, particularly that the court make the determination in substitution of the Director General that it is satisfied that the conditions of the law were met, was still not open to it. The legislation assigns to the Director General or his delegates, not to the court, the task of attaining satisfaction, which is a function that could not be usurped by the court. And neither could the court make the declaration that she was entitled to unemployment benefits. So that would be an articulation of the rules or legal principles. And I explained the importance and so on. Now, questions so far, comments? Questions, comments? None. Now, so there's a chat, let me have a look. Okay, and by the way, Curdy, thank you very much for sharing. Thank you very much. Now, thank you very much. The question I have is, should we move over now to the tutorial, or should we do one more and look at that? Oh, so from Louise, we should move to the tutorial now? Okay, so I think we should do that because we might be taking up too much time. Perhaps after this tutorial, we could then go back to me providing some suggestions on how to do peer miking and peer feedback. So I would definitely say that this was a very good attempt on the part of Curti in writing this, and I get a sense of a lot of the facts, but on the whole, although this was a very good attempt, there were just some parts which were crucial, but which were missing. So thank you very much, Courtney, for sharing your case note. Okay, so we're gonna head now to the tutorial. So tonight, we will talk about judicial review remedies. So in previous weeks, chats, hang on. Okay. So in previous weeks, we had covered issues about the legal standing of the applicant, whether the applicant had local standing. We talked about grounds for judicial review. So we talked about the grounds in terms of the exercise of discretion, in terms of Wednesday and reasonableness. We talked about whether or not there was evidence or not, and so on. So we've discussed that. We also talked about whether or not the case was actually one that involved non-justiciability. In other words, it was not apt for the court to examine because it involved a political question or an issue that was best left to the elected members of the government. So we talked about that as well. But a crucial point at the end of the day is actually judicial review remedies, because even assuming that you know that, if you were the lawyer and you had a client, even if you knew that your client has legal standing, even if you know that your client's rights, interests, or legal expectations, legitimate expectations, might have been impaired or breached by a decision of the decision maker, even if you knew that, even if you knew that there was a ground for judicial review, even if you knew that this was a proper question that should be determined by the courts because it involved a question of law, at the end of the day, the question still remains, if you were to apply for the judicial review, what do you get out of it? Will the court grant you the remedies that you have sought? So we will recall that, I think in week 2, one of the crucial questions you always ask is, what is the judicial review remedy that you're asking for from the court? So that is something you need to ask. Because if you follow Green versus Daniels, it is possible that the court will agree that your rights have been breached, but the court will not do anything, cannot grant you the remedy that you have sought. And it also highlights for us, it is crucial for us to determine what exactly is the judicial review remedy that we're looking for. And as far as the judicial review remedies is concerned, is that based on the ADJR Act or on the Administrative Decisions Judicial Review Act of 1977 Commonwealth? Or are you seeking judicial review on the basis of Section 75(5) of the Constitution, which gives the High Court the original jurisdiction to issue writs of mandamus, prohibition, or injunction against an officer of the Commonwealth? Or do you base it on Section 39B of the Judiciary Act of 1903? Because we will observe that in relation, for example, to Section 75(5) of the Constitution, in relation to the powers of the High Court, and in relation to Section 39B of the Judiciary Act of 1903, which gives the Federal Court of Australia the power to undertake judicial review, the remedies available to these two courts are limited to prohibition or mandamus or injunction. In relation to Section 75(5), the court has said that these are constitutional writs, which means, therefore, that it is beyond the power of the Parliament to curtail the exercise of these writs or the issuance of these writs by the High Court, because these are constitutional writs. They do not emanate from the Parliament. It comes from the Constitution. The High Court has also said that certiorari, or the power to quash a decision, is an ancillary remedy that also belongs to the High Court and also belongs to the Federal Court. So the certiorari, which is the power to quash an administrative decision, is not a constitutional writ because it is not in Section 75(5), but it is still within the power of the court to issue when its jurisdiction has been invoked in a proper case. So tonight, what we are going to do then, after studying this topic, you should be able to discuss and explain the distinction between common law prerogative judicial review remedies and equitable judicial review remedies. And even if we know that a lot of the remedies are now present in the ADJR Act, the application or the exercise of these judicial review remedies still lend a lot, is still curtailed or evaluated to a great extent on the basis of case law. And that relates to common law and or equitable judicial review remedies. We will also try to examine the specific common law prerogative judicial review remedies of certiorari, mandamus, prohibition, and habeas corpus, the specific equitable judicial remedies of declaration, injunction, and the statutory judicial review remedies. So as far as the statutory judicial review remedies are concerned, there are two sources. One is the ADJR Act of 1977 Commonwealth. The other one is Section 39B of the Judiciary Act of 1903 Commonwealth. Okay, so what we're going to do is we're going to go through 4 case problems to enable us to understand judicial review remedies better. So, can I have somebody please to read problem 1 for us? Just to read the problem.
I'll read it, Manjo. It's Emma.
Thank you, Emma.
Darren Wilkins operates a car rental business and has been doing most of the business accounting tasks on his own. An audit by the Australian Taxation Office, ATO, revealed that he had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of $59,965. The ATO informed him that under the relevant tax laws, he must pay his tax deficiency within 15 days or it would garnish all his business and personal bank funds. Darren has come to you as a solicitor for advice. Advise Darren on the judicial remedy or remedies that are suitable to prevent the garnishment.
Okay, very good. Thank you, Emma. So we have a dilemma here. Imagine you're Darren, and the ATO has said that they are about to garnish all your business and personal bank funds. Can you imagine that? You're gonna run out of money. How can you run your business? So there is a problem. There's an urgency there. And so Darren has come to you as a solicitor for advice. He's asking whether you can prevent the garnishment. That's the basic question. Okay, now, looking at the facts, what in the facts appears to be unclear? Before we talk about grounds for judicial review, is there anything in the facts which is unclear? And
what the law is?
Go on.
So what does the statute provide in terms of the powers of the ATO?
Okay. Now, actually, Monique, we don't really know if there is a statute for this. We assume, because it's the Australian Taxation Office, we assume that he is exercising his powers under a statute. We can make that assumption, correct? But we can also equally assume that he may be exercising certain executive powers or certain prerogative powers which are non-statutory. We don't really know because the facts don't indicate. I'm just trying to signal that. Okay, so when you look at this, we don't know if the whether or not the decision of the ATO was based on a statute. We could assume that. Or whether it was based on the exercise of certain prerogative powers. Because remember, it is understood that part of the prerogative powers of the Commonwealth or the executive is the power to tax. That is an inherent power of the executive. From long ago, the king was always imposing taxes. So that is a given. We don't really know when he did this. We can assume. It is based on an enactment or a statute? Probably not. Now, in that case, therefore, if that is the scenario, if the decision has been based on an enactment, then potentially we could say that because the decision was based on an enactment, meaning a statute, then the judicial review remedies can be based on the Administrative Decisions Judicial Review Act of 1977 Commonwealth. On the other hand, because the facts are not clear, if we can suppose that the decision of the ATO was actually based on the exercise of prerogative powers or the non-statutory executive powers, then the ADGR Act does not apply. So let's clarify that for now, okay? Now, I don't want you to get into that aspect of, is that a prerogative power or not? Because that's really a constitutional question. I just want to highlight for now that we don't know the legal basis for the exercise of executive powers. So that's one. So having said that, before we can even talk about a judicial review remedy, we know that that Darren Wilkins has legal standing, obviously, right? He's got certain rights and interests to his funds. They cannot just be garnished, and because it is a basic right that we know that no person can be deprived of his property without a valid basis for that, and that's following the case of Entick versus Carrington, for example. So the other question we ask is there a ground for judicial review? Before we can talk about the judicial review remedy. Is there a ground for judicial review? What is that? What do you think? Because if there is no ground for the judicial review, in other words, if we cannot assert that the decision is invalid or contrary to law, then you can't go to the court, because how can the court provide a remedy if the decision is lawful in the first place? Okay, so from Jess, is that Jess or Jessie?
Jesse.
Jesse, thank you, Jesse. So, according to Jesse, there seems to be Wednesbury and reasonableness. And from the viewpoint of Monique, there seems to be, an excessive exercise of power. Now, those two are actually related, because if we recall, in relation to Wednesbury and reasonableness, the courts have said that the arbitrary, capricious, and oppressive exercise of executive power amounts to Wednesbury and reasonableness. So actually, both Monique and Jess are touching on the same ground of illegality here. And that is Wednesbury and reasonableness, because the actions of the ATO constitute or demonstrate an oppressive, capricious exercise of executive power. Because the courts have said that when there is an exercise of power that is less oppressive, then that is the preferred route to be taken. So there is one ground. Is there a second ground for judicial review? There is a ground for judicial review. One of them relates to
natural justice.
That's right. So the second ground that we have here is actually the right to natural justice. We recall from the case of Entick versus Carrington that before anyone's property can be seized, he must be given an opportunity to be heard. That is a basic right of every citizen. So there are two grounds for judicial review. Very good. So we can move on. Okay. Let's talk about particular judicial review remedy or remedies. So what would those be? So from PETA, prohibition. Okay, what exactly is a prohibition as a remedy? So that's right. So from PETA, prohibition actually stops any further action when the court determines that there has been a lack of jurisdiction on the part of the executive in making a decision, or that there is an excess of jurisdiction. Because there seems to be a breach of natural justice, and because there seems to be Wednesbury and reasonableness in the decision of the decision maker, it can be argued, therefore, that there is a lack or excess of jurisdiction in the exercise of the power of the decision maker. And for that reason, a writ of prohibition is available. If we found it on, if we assume that we base it on Section 75(5) of the Constitution, that would be the source of a writ of prohibition coming from the High Court, or we can rely on Section 39B of the Judicial Act of 1903. If the application for judicial review is made with the Federal Court of Australia. Now, it is actually possible that, assuming that this particular decision was based on an enactment, it is actually possible for an application for judicial review to be based on the ADGR Act. It can also be based on Section 39B of the Judicial Act of 1903, because these two statutes can actually work at the same time. The writ of prohibition under the Section 39B of the Judicial Act is just more specific, and as I said, more limited, because the judicial review remedies under Section 39B would only be the writ of prohibition or mandamus or injunction. Okay, so that's one.
Manda,
yes, Jesse.
if we received such a question in the exam, and facts would have us assuming as to whether the decision was based under an enactment or under a prerogative power, would you expect us to plead the alternatives in the exam?
Yes.
I know I've asked it before, but would you say, assuming that there was no decision under enactment, then you'd go in and discuss Section 39B? or in the alternative, if the decision was made under enactment, then you'd go through the ADJR Act.
You're right. You will have to state alternative assumptions here. However, when I write in relation to the final take-home paper, I will be very explicit with the facts. I actually won't have any of those incomplete ones, just to avoid any confusion. So I will say that the decision was based on an enactment, or I will cite a statute, or I will say that it is based on the non-statutory executive powers. I will make that clear. Okay? Now, so prohibition is one. But the problem with the prohibition is that it can take a while for the court to grant the prohibition. Because the court has to be convinced that it's unlikely to be ex parte. The court will have to be convinced that there was a ground, there's a ground for judicial review, and that will probably require hearing. So while ultimately the actions of the ATO can be stopped, can be prohibited on the basis of a court order, that can take a while, couldn't it? So in that case, the funds of Darren Wilkins will still be garnished. Can you see the problem there?
If that's the case, Manjo, then it can then apply for certiorari, however you pronounce it.
Yeah, the problem with the certiorari is that it's even more problematic because the effect of certiorari is to quash the administrative decision. But if you recall, as far as the writ of certiorari is concerned, what is important is for the court to examine the records of the case. It will actually, before a certiorari can be granted, the court will examine, the application that was presented. It will also examine the actual order. So that will take a while. That will probably require a trial before certiorari can be granted. And so if you wait for that, the funds would have been garnished and Darren Wilkins' business can close down. Now there's the good answer there from Marcos and from Courtney. Injunction, particularly interlocutory or interim injunction. Very good. So that is the proper answer here. You will apply both. The most important remedy here would be an application for an interlocutory prohibitory injunction. Interlocutory prohibitory, because there is another injunction known as mandatory injunction to order somebody to do something. But in this case, we're talking of an interlocutory prohibitory injunction following Castlemaine Tooheys Limited versus South Australia. And before the interlocutory prohibitory injunction can be granted, it will have to be indicated, it will have to be clear to the court that there is a serious question to be tried, or that the plaintiff is most likely entitled to the relief sought, that the plaintiff will suffer irreparable injury which cannot be cured by damages unless the injunction is granted, and that the balance of convenience favors the granting of an injunction. That is most immediate, because that can be done ex parte.
Excuse me, Manjo.
Yes.
It's Monique. If they had not yet made a finding, but they'd made, some initial sort of inquiries or allegations of his debt, but still said that in 15 days we're going to garnish these things, would that still be applicable, or would the decision have to have been sort of final or made?
No, very good point. I think are you trying to relate this to Australian Broadcasting Tribunal versus Bond, the difference?
Yeah, so would these remedies apply if it was sort of like a preliminary decision or a step in the decision-making process?
Yes, because there is actually a substantive or an operative decision. The substantive and operative decision is that Darren Wilkins' business, his funds, will be garnished. So that is a substantive or operative decision already. And
okay, thanks.
So at that point, there has been a decision made, and the decision to be made was, the decision that was made was actually to garnish his funds. And therefore, if that would then violate or impair the rights of the right to property of Darren Wilkins. So in that case, a judicial review remedy can be sought. Okay, so are we clear? So, from Peter, you're smiling or laughing, Peter. Yes, so we're good? Okay.
I'm just laughing at Jesse's comment, actually.
What was Jesse's comment there? Oh, right, he could move all his money to his wife. Yeah, that's true. Okay. That's right. Okay. Some people have done that. Oh, the other thing you will notice is that, and this is, probably something you will examine when you do corporations law, even his personal bank funds were to be garnished. And we know that if a person has put up a proprietary limited company, then the proprietary limited company has a legal personality which is distinct from that of the shareholders. And so it becomes a real question of whether or not the ATO can actually garnish the personal bank funds as well. So that would have been one of the grounds for judicial review, because to garnish the personal bank funds would have been contrary to law, because that doesn't belong to the business of Darren Wilkins. Okay, so let's proceed. Question number 2. Can somebody read that question for us, please? So going back to question 1, I'm just going to go straight to the judicial review remedies. We've covered the issue about standing. We've talked about the grounds for judicial review. Let's just talk about the judicial review remedies. There are 2 judicial review remedies here. One is an application for the issuance of an interlocutory or interim prohibitory injunction, which is ex parte. And 2 will be an application for a writ of prohibition. And in either case, those are very specific judicial remedies. And in either case, that is permitted under the ADJR Act as well, because the courts, the federal court or the federal circuit court, have the power to issue any order as it sees fit. Okay. So that would be that would be the advice you should be giving. Okay. Question 2. Can somebody read question 2 for us?
I'll read it, Manjo.
Yeah.
The Francois Mills Proprietary Limited applied for a broadcasting licence with the Australian Broadcasting Agency, ABA, and to be allowed to post a bond of $500,000 for the licence. Under Section 43A of the Australian Broadcasting Standards Act, Commonwealth, a broadcasting licence shall only be issued by the ABA upon payment of a bond of $5 million by an applicant for the licence. Section 43B of the Act also provides that the ABA board has the power, which it may or may not exercise, to reduce the amount of the bond required under Section 43A of this Act. The ABA refused the application licence to Francois Mills Proprietary Limited until it posted a bond of $5 million. Francois Mills Proprietary Limited has approached you as a solicitor for advice. Advise the company of their judicial remedy or remedies that might be available over the ABA decision.
Mm-hmm. Okay. What do you think? Thank you, Peter.
Oh, I don't think that he's got any real grounds to apply. I think that they've, if it's open to them to make that decision to reduce it or not, and they've decided not to, then, well, they're still acting within the powers granted under the statute.
Mm-hmm. That is actually the correct answer there. As pointed out correctly by Monique, I would advise that a judicial review remedy is unavailable in this instance because the decision of the decision maker is actually lawful. It is according to law. And it involves the exercise of a discretion, and the discretion has been exercised reasonably. And so therefore the decision is actually lawful and there is no ground for judicial review. So the answer there is, I would advise the company that a judicial remedy, it's unfortunately not available in this instance because the decision is lawful. okay, because it involved the reasonable exercise of a discretion, which courts will not interfere with. Courts will only interfere with the exercise of a discretion, one, when it is unreasonable, so that would go against Wensbury and reasonableness, or two, when it is contrary to what the law provides. So we recall that even when absolute discretion is granted to a decision maker, such exercise of discretion would still be limited by the purpose and aims of the law. So there is no such thing as absolute unfettered discretion, which is beyond the control of the courts. The exercise of discretion, even if it is stated as being absolute, must still be exercised reasonably. So here the answer would be, as pointed out correctly by Monique, I would advise the company that there is unfortunately no judicial review remedy that is available because the decision of the ABA is lawful. Okay, question 3. Can somebody read question 3 for us?
Were you talking to me?
Anyone can volunteer to read question 3.
The Security Workers Act Commonwealth requires anyone seeking to practice as a security worker in the Commonwealth Department, agency or office to obtain a licence from the Australian Department of Social Services, ADSS, and to meet certain requirements relating to education and training qualifications, and physical and moral fitness. Sherlock Gordon applied for a security workers licence with the ADSS in compliance with the Security Workers Act Commonwealth. His application was denied, however, because he appeared fat, although his body mass index, BMI, showed that he was of normal weight. Sherlock has come to you for legal advice about the DSS decision. I think this has been debated before on Facebook.
I've changed the facts because the facts here now say he appeared fat. It does not say he is overly obese. This is different. Okay, this is different. I've changed the facts. The facts now say that he appeared fat, although his body mass index showed that he was of normal weight. In the facts of the quiz, I said he was overly obese. Here I said he appeared fat. Okay, so having said that, we tick off the boxes. Does he have standing? Yes. Is this a justiciable question? Yes, it seems to be involve a legal question. Is there a ground for judicial review? What is the ground for judicial review? As Emma said, this is an instance of Wensbury unreasonableness. Because the fact alone that he appeared fat, that's a subjective opinion, obviously. It appears to be a wrong subjective opinion because his body mass index showed that he was of normal weight. And so therefore, any reasonable decision maker will have to come to the conclusion that this person actually meets the requirements pertaining to physical fitness. Correct? How can you say that he is physically unfit if his body mass index shows that he is of normal weight? So there's a ground. Are we clear about that? So this is an instance of Wensbury unreasonableness. Clear. So we have a ground for judicial review. Now, if there's a ground for judicial review on the ground that this decision is unlawful for showing, Wensbury unreasonableness, in the sense that no reasonable decision maker could arrive at a decision to say that he does not meet the requirements about physical fitness. So there's a ground for judicial review. The next question is, what remedies can you ask for, and under what law or under what legislation? Let's talk about the remedies now. What specific judicial review remedies will you apply for? And where will you base it on? Are you basing it on statute? Meaning, is it based on the ADGR Act? Is it based on Section 39D of the Judiciary Act? Are you going to go to the High Court? What do you think? First question is, because what we need to remember is that if an administrative decision was actually based on an enactment, therefore the ADGR Act applies. It is better to file an application for judicial review under the ADGR Act because, in a sense, it involves a codification of the grounds for judicial review. Section 5 enumerates various grounds for judicial review. And secondly, it also enumerates, particularly in Section 16, the various powers that the court has in terms of granting a judicial review remedy. So your preference should always be the ADGR Act of 1977 Commonwealth when that is available. Okay, so clear. So we know, as pointed out by Leonie and Monique, that the ADGR Act is likely to apply because the decision is based on an enactment, which is the Security Workers Act. So what are the particular judicial review remedies that you're looking for? For Marcos, you would like the decision to be quashed. Okay, for a decision to be quashed, what exactly is the remedy there? Okay, so what I'm trying to do now is to try to connect a discussion of the statutory judicial review remedies with common law and equitable judicial review remedies, okay? Because the judicial review remedies which are available at common law or as equitable remedies have in a sense been codified in a statute. But even in the absence of these judicial review powers under the ADGR Act or even under Section 39B, there exist always, as we know, certain judicial review remedies that belong to the courts as a way of policing the actions of the executive. So I'm trying to draw a connection between common law and equitable judicial review remedies and how they look like when you look at it from the viewpoint of the ADGR Act. So one of them would be to apply for the decision to be quashed or set aside. The decision not to grant him a license to be quashed or set aside. And you can base that under Section 16(1)(a) of the ADGR Act. Now, that particular remedy or would be equivalent to what is known as the writ of certiorari, which is a common law remedy, judicial review remedy. That is the writ of certiorari. So that one, the quashal of a decision, is the equivalent of a writ of certiorari in common law, or what is known as a prerogative judicial review remedy. Because there are only two there are at least two important equitable review remedies that we know. One is injunction. The other one is actually declaration. So that's one, quashal. Number two, is there anything else you can ask for the court to do? So declaration for quashal defer back to the original decision maker. Wait, Monique. So you say declaration for quashal. What is that? Are they one and the same? Are they connected? Are they distinct remedies?
Sorry, I meant to seek that the decision be quashed, seeking from that declaration from the court that the decision's to be quashed.
Okay, those are actually two distinct.
Okay, sorry. Can you explain that, please?
Yes. So one is the quashal of a decision amounts to what is known as the issuance of a writ of certiorari. And by issuing a writ of certiorari, the court will actually quash the original decision maker so that it no longer operates. It becomes inoperative because it has been quashed. Now, the other thing but sometimes you feel that, assuming that it's quashed, the rights of the applicant are still unclear. And you would wish that somehow, if it is open to the court to make a ruling as to the rights of the applicant, you would like the court to make a finding whether or not the applicant has certain rights. In that case, that is called a declaration, a writ. You're asking for a declaratory writ on the part of the court to say that these are the rights of the applicant or not, that the applicant does not have any rights. So that is a declaration. Now, in Section 16, 1C of the ADGR Act, the court actually has the power to make a declaration as to rights. That is a discretionary remedy. Let's be clear. That is a discretionary remedy on the part of the court. The court may decide not to grant a declaration, but if it is clear to the court, such as here under the facts, that the applicant is clearly entitled to a license and that he has a right to a license as a matter of course because he meets the statutory requirements, he can actually apply for a declaration that he has a right to a license. And I would think that the court is likely to issue a declaration that the applicant, Sherlock Gordon, is entitled to a license. Now, the advantage of the declaration is that what then happens is that decision makers, not only would his decision be quashed, the decision not to grant the license, not only would that be quashed, but because there is now a declaration coming from the court that he is actually entitled to a license, then the decision maker is likely to issue a license in accordance with the finding or the declaration made by a court.
Excuse me, Banjo, can you just compare that to Green and Daniels where the court felt it was not appropriate for them to make a decision?
Very good question, Monique. So there is a difference here because if you look at the facts, is there any wiggle room for the decision maker to say that the license should not be given? Is there a wiggle room there? Is there any scope for the decision maker to say that Sherlock Gordon is not entitled to a license? Is there any scope for the decision maker to arrive at that decision?
I guess only if he doesn't meet the requirements. But then in the facts it suggested that he did.
Correct.
So
under the facts,
yeah,
it is a matter of right because he met the statutory requirements, right? There is no discretion on the part of it would be unreasonable for a decision maker to insist that he is simply exercising his discretion not to grant a license. That would be an unreasonable exercise of the discretion, which we know courts can police, because even the exercise of discretion must be done reasonably. If the decision maker therefore decided not to grant the license, alleging that it has a discretion not to grant the license, that is likely to be unreasonable. As we have already said initially, this seems to meet the standard of Wednesday unreasonableness. So here, there is no scope to refuse the issuance of a license. There is no scope because it meets the statutory requirements. So if a person meets the statutory requirements, he must be granted a license. Are we clear with that so far? Clear? Clear. It becomes a matter of right. Once a person meets the statutory requirements, he must be given that license as a matter of right. It can even be ordered by writ of mandamus, as I will indicate shortly. Now, the case of Green versus Daniels is different because that particular law, the statute itself, still left in the decision maker some discretion pertaining to the payment of unemployment benefits. There was still some scope for the exercise of discretion. One, it involved a determination of whether or not the applicant tried to look for a job, to what extent the applicant attempted to look for a job. There were questions of whether or not there were actually jobs available during that time. There were factual questions of whether or not there were a lot of other applicants, school leavers trying to look for a job, therefore others are unlikely to find jobs. So the facts there were different according to the court. There was discretion on the part of the decision maker, therefore, to grant the unemployment benefits or not. There was discretion because of these, at least four factors that could be considered. Here, there is no scope for the exercise of discretion. Are we clear? So is that okay? We're good?
Yeah, that's great. Thank you.
Very good. Now, so we've already identified two potential judicial review remedies. One is a quashal of the decision, which amounts to the issuance of a writ of certiorari. The second one is an application for a declaration that Sherlock Gordon, as a matter of right, has a right to a license. So that is a writ of declaration, as well as, in particular, the Section 61C of the ADGR Act. But there is a third judicial review remedy. And that is actually, if you base it on Section 39B of the Judicial Act of 1903, you could actually ask for the issuance of a writ of mandamus. So when there is a public duty, and there is a public duty there, in other words, to grant particular rights, and there is no question about that the rights exist, then a decision maker, a public authority, can be compelled to act in a particular way. That is what mandamus is all about. So here, I think we agreed that as a matter of law, Sherlock Gordon is entitled to a license. We know that, right? I mean, we've already discussed that. And because he is entitled to a license, and there is simply no wiggle room, no discretion on the part of the decision maker not to grant him a license, you can ask the court to issue an order to compel the issuance of a license. So 3 things: quash the decision not to grant him a license. 2, ask for a declaration that he has a right to a license. But 3, you can also ask the court to direct the ADSS to grant him a license, and that will be covered under Section 16D of the ADGR Act, where the court can issue an order in whatever it finds necessary according to the circumstances of the case. That is equivalent to the issuance of a writ of mandamus here. And the writ of mandamus arguably is available because this involves a public duty. There's a duty now to grant a license because there is a right on the part of Sherlock Gordon to the license. Are we clear? Questions? We're good?
Manjo?
Yes, Emma.
Why would you choose one particular remedy over another? So you've said like we had a certiorari available, there was the declaration available, and then there's the mandamus available. So why would we choose
all 3?
one over
I mean, if you could have it all, you'd go for you go for all, right? Because if you just went for the quashal of the decision, what then happens is that the decision not to grant him a license will be quashed. So there is no decision. But still, Sherlock Gordon does not have a license. He wants a license. That's the point. So,
okay, I'm a bit confused as to when you would go for a statute remedy versus a common law or equitable remedy. I'm a bit confused.
Okay.
Which one's better than the other, and why you'd go, like when one would apply, or I don't really know what I'm trying to say, but I'm a bit confused.
Yeah, I think what you're getting at here, but that's actually a different question from your initial question, Emma, and I'll go back to that because your initial question, your first question was, why are we looking at 3 potential remedies here? Quashal, declaration, mandamus. Okay.
Yeah, I understand that now. When you said he wants a license, I get why you'd go for mandamus because he'll get a license. So I get that, but I don't understand why you'd go for a statute remedy versus a common law versus an equitable remedy.
Very good. Okay, so having that's a good point by Emma here. As I pointed out, if an administrative decision is actually made on the basis of an enactment, meaning it was made under an enactment, you would like to apply for judicial review under the ADGR Act, because that is the purpose of the ADGR Act. It simplifies the judicial review process, and it provides clear grounds for judicial review, as indicated in Section 5 of the ADGR Act. But at the same time, it also clarifies and expands on the power of the courts to provide judicial remedies. And there are 4 of them under Section 16. Okay, so if you can apply for judicial review under the ADGR Act, do so. Now, having said that, even if a decision was actually made under an enactment, we need to remember that it does not displace the power of judicial review under Section 39B of the Judiciary Act. Neither does it displace the common law judicial review remedies. They coexist. Now, what I had simply done was that I want to make it clear that when Sherlock Gordon applies for judicial review, we'll actually base it on the ADGR Act. I want to be clear about that. So because the decision was made under an enactment, when he applies for judicial review, he will base his application for judicial review under the ADGR Act, and the judicial review remedies will be based particularly under Section 16 of the ADGR Act. Are we clear about that? Now, however, what I actually attempted to do earlier was to draw a connection between the specific powers under the ADGR Act and what are known either as common law or prerogative remedies or equitable remedies. I was just trying to draw a connection because what we call quashal is actually equivalent to a writ of certiorari. That's what I was just trying to do. So that assuming an executive decision was not made under an enactment, so that the decision was perhaps based on the exercise of prerogative powers, you can still apply for judicial review by applying for a writ of certiorari. That's what I was trying to do. Okay, just trying to draw a connection. I was also trying to, the other thing I was trying to do was that assuming that the ADGR Act was unavailable because the decision was not made under enactment, there is a writ of declaration that can be sought from the courts. And the writ of declaration is the power of the court to issue an order declaring what the rights or the interests are of an applicant. Now, the writ of declaration is equivalent to Section 16(1)(c) of the ADGR Act. Now, the third remedy is actually the issuance of a writ of. So, no, the other thing about the writ of declaration is that it is actually known as an equitable remedy. Okay. If you were to look at it from the viewpoint of outside of the statutory scheme of judicial review, the writ of declaration is what is known as an equitable remedy, so that not only is it discretionary on the part of the court will only grant an equitable remedy of declaration when there is no other available legal remedy. So it is kind of a remedy of last resort. Okay, so that's the writ of declaration. Not only is it discretionary, meaning the court can refuse to grant it, but in addition, as far as the equitable remedy is concerned, the court will only grant it if it determines that there is no other available effective legal remedy for the applicant. So from Emma, so if it's not under enactment, when would the other statutory remedies apply? So if an administrative decision was not made under an enactment, then we know that you cannot seek recourse under the ADGR Act of 1977, right? We know that because the ADGR Act applies only when an administrative decision is made under an enactment. So it is important for us to know if an administrative decision is not made under an enactment, because it is based, for example, on the exercise of non-statutory executive powers, there is still recourse to judicial review. You can base it, one, on Section 75(5) of the Constitution, which gives to the High Court original jurisdiction to issue writs of mandamus, prohibition, or injunction against an officer of the Commonwealth. So there's the question of whether or not a decision was made by an officer of the Commonwealth. That's the basic question there. So if the decision maker was not an officer of the Commonwealth, then you can't seek recourse under Section 75(5). Neither can you seek recourse under Section 39B of the Judicial Act of 1903, because the power of the federal court to issue writs of mandamus or prohibition or injunction will only be in relation to a decision made by an officer of the Commonwealth. So if a decision was not made under an enactment, ADGR Act does not apply. Now, if the decision was not made by an officer of the Commonwealth, which means Section 39B of the Judicial Act of 1903 cannot apply, neither can Section 75(5) of the Constitution apply, then you could potentially have recourse to common law judicial review remedies. Okay, and in which case, as far as common law judicial review remedies are concerned, you can have a writ of prohibition or a writ of certiorari. These are common law prerogative or common law or prerogative judicial review remedies. You have an equitable remedy of declaration. You can even have the injunction, for example, is known as an equitable remedy. And the advantage of an injunction is that it can actually be fashioned to the needs of an applicant, and it can be directed not only to public authorities, but even to private individuals. We need to remember that common law prerogative remedies only apply in general to public officials. But equitable remedies, particularly in relation to injunction, they can be ordered against, they can be issued against even private individuals. Okay. We're good? Was that clear enough? Okay.
Yeah,
May I just...
Question.
Peter, yes. Go on, Peter. Peter is hung, I think. Oh, did I hang? Am I the one who hung, or is it Peter? Wait, what happened here? What?
Stuff.
Emma, you might want to explain that 10-minute answer you just got.
Yeah, sorry about that, guys. I didn't mean to steal the floor.
Hang on, sorry. I kind of disappeared there for a while. I'm just trying to look for the recording button here.
It's
the recording is
my end, Manjo.
Very good, very good. Okay, Peter, you had a question for me. What was the question there?
No, I was just saying that Emma's question was brilliant, and your answer explained a lot of what we've been discussing tonight. So I thought it was a great answer.
So I clarified and properly answered the question.
Yes.
Okay, thank you. Thank you for that comment. Okay.
Manjo, sorry.
Go ahead.
I had a question about whether there's a definition for a Commonwealth official or an officer of the Commonwealth.
That is actually kind of a constitutional law question. So if you go to constitutional law, there are some identifiable officers of the Commonwealth and some who might not be. So for example, an officer of the Commonwealth would be members of Parliament, members of the executive, but who are not examples of officers of the Commonwealth. Well, at the top of my mind, okay, so you will notice that what the Commonwealth has done is actually to privatize certain industries. It has also delegated certain public functions to private individuals. So for example, in relation to the Manus Island before, we will recall that there was a private agency that was involved with the detention center, right? These are not officers of the Commonwealth. These are examples of persons who are not officers of the Commonwealth. Which means, therefore, if one of these security officers who are who belong to a private agency controlling Manus Island detained an individual, did not allow an immigrant or a boat refugee from leaving the premises, can you apply for a writ of habeas corpus against that security officer? And the answer is no, because in that particular case, he is not an officer of the Commonwealth. Assuming that in relation, for example, to customs, assuming that part of it has been privatized as well and given to a private agency, if they make a decision, for example, to impose fines, can you apply for a writ of mandamus or prohibition or injunction against that particular firm? The answer would be no, because he wouldn't be an officer of the Commonwealth. Now, there was a question, members of Parliament, ministers. Yes, ministers are officers of the Commonwealth. So you will notice that in a lot of immigration cases in administrative law, the case is actually applied against a minister of the Commonwealth because he is an officer of the Commonwealth. So a lot of the administrative law cases actually are based on Section 75(5) of the Constitution or Section 39B of the Judicial Act of 1903 if the application has been made with the Federal Court of Australia. Okay, questions? Another might be, let's assume that there was an enactment that was made, and the enactment, for example, constituted the Australian National University. Assuming, okay, let's assume that the ANU, I'm not really sure, assuming that the ANU was created on the basis of a Commonwealth law, which might be the case. And let's assume that the ANU, because you have the case of ANU versus Burns, right? Let's assume that the ANU issued an order under an enactment, under the ANU Act, relating to somebody whose rights were impaired. So we're clear with that example? ANU versus Burns said that the decision to terminate the services of Burns was not under enactment, it was based on contract. That's fine. But let's assume that there is a case where the ANU Vice Chancellor made a decision on the basis of the ANU Act. And let's assume that the ANU Act is a Commonwealth Act, okay? The question is, the decision of the Vice Chancellor of ANU, would that be a decision of an officer of the Commonwealth? The answer is no. So again, that's an example of an instance where you have a decision made under an enactment, under the ADGR Act, but for our purposes, the decision of the Vice Chancellor of ANU would not have been, you couldn't have had recourse to Section 75(5) of the Constitution or Section 39B of the Judicial Act of 1903 because the Vice Chancellor of ANU would then be considered an officer of the Commonwealth. Okay, so I guess we're good. Questions, comments? Oh, Kirti J, she's doing a presentation tonight. Yes, we're still good, Kirti. And then, you know, if we're done, hang on. Okay, if we're done, I'd like to give the floor to Kirti to do a presentation. Any questions before we end tonight's tutorial? None? Okay, so thank you very much. Please stay on if you could. And I'm gonna give the floor now to Kirti to give a 5-minute presentation, video presentation. Thank you. Thank you everyone for joining tonight's session. I hope to see you again next week. You could go if you want, but otherwise stay on because Kirti will do a live presentation. Kirti, can you share your screen now for us? Kirti, are you there? Oh, very good. Okay. Please turn on your microphone, Kirti. You're on mute.
Sorry. Okay. How's that?
Yep, we could hear you.
All right. Is that screen all right?
Yes.
Okay. Cool. Am I right to begin?
Yes. Go ahead.
Yep. Good evening. My name is Courtney Beveridge, and today I will be presenting the case note of Sisbel and Minister for Immigration and Indigenous Affairs, 2006-228 of the Commonwealth Law Reports 58. This case is relevant to the Week 7 topic, natural justice. Today I will be discussing the facts of the case, the legal issue, the court's decision, and the importance of the case in relation to natural justice. The facts of this case are as follows. This case concerns a seaman of Iranian descent who, on April 7, 2001, jumped ship on Port Kembla while on the vessel in which he was serving. The appellant applied for a Class XA protection visa, which was rejected. The appellant applied for the decision to be reviewed by the Refugees Review Tribunal. The application was dismissed. The applicant is now appealing. The appellant claims his reasons for jumping ship was due to a fear for his life. This fear manifested when the appellant abandoned his Islamic faith and became a born-again Christian. The applicant appealed the decision on grounds that the Refugee Review Tribunal made a reviewable error when making its decision. The legal issue is whether under Section 36, subsection 2 of the Migration Act, 1958 of the Commonwealth, the appellant, due to a justifiable fear of being killed, was outside Iran and unwilling to avail himself the protection of Iran. In order to grant a Class XA protection visa, the tribunal must have been satisfied on these grounds. The tribunal was not satisfied. The convention reasons for the Class XA protection visa included race, religion, nationality, political opinion, or being a member of a particular social group. The tribunal found that minor discrimination or minor harassment did not qualify as fear of persecution. The tribunal concluded that the criteria under Section 36, subsection 2 of the Migration Act was not satisfied. Therefore, the tribunal was not satisfied that Australia had an obligation to protect the applicant under the Refugees Convention.
The tribunal went on to address the 4 grounds of appeal. The first ground of appeal was dismissed as it was found the captain of the ship acted reasonably and acted in a way that any other captain would have been expected to act. The second ground of appeal was dismissed as it was found that the appellant's freedom to move around the ship, at one point being able to leave the ship to seek medical attention, did not support a well-founded fear of being killed. The third ground was dismissed as the court did not accept the appellant's reason for jumping ship to be that he feared for his life. The fourth ground was dismissed as although the tribunal accepted its requirement to reveal its decision, it did not accept that it required to reveal its thought process in reaching the decision. Judge Graham found no error in the tribunal's conclusions and dismissed the case with cause. This case is a good example of natural justice as it affects the rights, interests, and legitimate expectations of the appellant. In the case of Keogh and West, Justice Mason spoke of natural justice when he said, "Natural justice and fairness are to be equated, and it has been recognised that in the context of administrative lawmaking, of administrative decision-making, it is more appropriate to speak of a duty to act fairly or to accord natural justice. The case of Sisbel and Minister for Immigration and Indigenous Affairs is a prime example of natural justice and procedural fairness. The appellant was given an opportunity to have his case heard, and furthermore, when unhappy with the judge's rulings, was given a chance to have the decision appealed. In the case before us, Justice Graham said, "What is required by procedural fairness is a fair hearing, not a fair outcome. This case is authority that procedural fairness is concerned with the process of the appeal, not with the outcome of the appeal. So long as an individual is given the opportunity to appeal the decision they are unhappy with, and the prior hearing rule has been complied with, then procedural fairness has been achieved." Thank you.
Well done. That's 4 minutes and 40 seconds. Well done. Fantastic. 5 out of 5. Well done.
Thanks.
Thank you. Very good. That was really good. That was really good. And you were very calm, and all the facts came out. The legal issue was identified well. You discussed the decision, the rules, and the importance. They were fantastic. Well done. You did really, really, really well. Okay.
Thank you.
Well done. Okay. So any questions before we end tonight's session? None? Okay, so thank you, everyone. And next week is going to be week 11. We're going to have, for the tutorial next week, we will have the revision. It won't be about freedom of information, which also means that our last weekly quiz there won't be any weekly quiz on Monday. We're going to postpone that to the week after, because as we said, we will only have a quiz when we can discuss the quiz as well during a tutorial. So there won't be any quiz for next week. We're going to move it to the week after. So thanks, everyone, and I hope to see you again next week. Good night. Bye.